And I will leave the floor first for my dear colleague, Vice President of Section 2 of the European Court of Human Rights, Marco Bošnjak. Marco's background is in criminal law, and he has also worked for several years as an advisor to the Constitutional Court of Slovenia. So the floor is yours, Marco. Thank you.
Dear President of the Constitutional Court, Mr. Arslan, dear other members of High Judiciary in Turkey, distinguished other guests and colleagues, it is my great pleasure and privilege to address you in this historical city of Istanbul, bringing together so many cultures and traditions. It is indeed an ideal place to cultivate judicial dialogue on so many levels. Today, I will not speak about the jurisprudence of the European Court of Human Rights, which I am a member of. I will rather speak about the experience with individual applications in my own home country, namely Slovenia. The possibility of an individual application to the Constitutional Court was introduced by the Constitution in 1991 and became operational with entry into force of the Constitutional Court Act in 1994. There are 4 different possible types of individual applications before the Constitutional Court of Slovenia. The first and probably the most important, at least in number of cases, is the constitutional complaint against individual acts, judgments, or decisions of the judiciary or administrative bodies. In annual new coming cases, the constitutional complaints make around 70 to 80% of all new coming cases. In addition to that, individuals may lodge a petition to review constitutionality of a law or a petition for review of constitutionality or legality of a bylaw. There are 2 other options, 2 other possibilities of individual applications which are much less relevant and almost never used, namely a petition to establish unconstitutionality of activity of a political party, and an application regarding confirmation of an election of an MP. The second or the 4th option can only be used by a specific candidate that presented himself or herself at the elections. First, I will turn my attention, or rather your attention, to the constitutional complaints. They can be lodged in cases of violations of human rights and fundamental freedoms, after exhaustion of all available legal remedies in the legal system, within 60 days from delivery of the relevant individual acts, and I must underline that they are excluded in certain, by law, in certain de minimis cases. We'll get to that later. When speaking about violations of human rights and fundamental freedoms, I must underline that the relevant provision that can come into play, ratione materiae, in cases of constitutional complaints are first and foremost the provisions of the Slovenian Constitution, but in addition to that, all other human rights and fundamental freedoms guaranteed by any international law instrument that has been signed and ratified by the Slovenian Parliament, namely according to Article 8 of the Slovenian Constitution, all international treaties that are ratified by the Slovenian Parliament are directly executable in the Slovenian legal system. In addition to that, according to Article 15 of the Slovenian Constitution, no human right or fundamental freedom can be limited or denied by claiming that it is not recognized directly by the Slovenian constitution. If it's recognized by any other act, it must be respected in the Slovenian legal system. Regarding the exhaustion of legal remedies, I must underline that the Constitutional Court is always the court of last resort. In criminal cases, this means that the case first has to go through the court of first instance. Then, after that, the applicant must use an appeal to the higher court, which is an ordinary regular appeal. Later on, an appeal on points of law to the Supreme Court, and only after all these remedies are exhausted can he or she turn to the Constitutional Court. In civil cases, it's very similar. First, the court of first instance, appeal to the higher court. Later on, the path to the Supreme Court is much narrower in civil cases. There is a leave to appeal in certain cases, or a direct appeal on points of law in certain civil cases. And if unsuccessful, then an applicant can turn to the Constitutional Court. In administrative cases, an individual who claims that he or she has been aggrieved by a violation of human rights or fundamental freedoms by an administrative authority must first start the so-called administrative litigation in the administrative court. Then, if he or she is not successful, must request a leave to appeal to the Supreme Court, or in certain cases, appeal on points of law is directly available for the applicants to the Supreme Court, and only after that can they turn to the Constitutional Court. Furthermore, due to an enormous rise of a number of cases before the Constitutional Court, due to the flooding of constitutional complaints before the Constitutional Court, the amendment to the Constitutional Court Act in 2007 limited considerably the number, the access to the Constitutional Court in the so-called de minimis cases, where it is considered that the applicant has suffered no significant disadvantage. This is the case where the dispute, the underlying dispute, is below 2,000 euros, where a decision is solely on costs of proceedings, where there is a trespassing case, or in cases of minor offenses like, for example, road traffic contraventions. However, still in such cases, an applicant can turn to the Constitutional Court and request that his complaint be examined if his case concerns an important constitutional question exceeding the circumstances of that particular case. And this has been a case in a number of important cases later on. So the Constitutional Court does open the gate if such is demonstrated by the applicant. Regarding the examination of constitutional complaints, the first step, the admissibility of the constitutional complaint is examined by a panel of 3 judges. In practice, around 95% of all constitutional complaints are dismissed as inadmissible at that stage already. Only 5% in general, on average, get to the next level. If a case is declared, an application is declared admissible, then it is sent to the public authorities that issued the contested decisions, and also to the adversary in the underlying proceedings. So, for example, if a defendant in civil proceedings lodges later on a constitutional complaint, if declared admissible, it is also sent to the plaintiff, and both the public authority, for example, the courts of first, second instance and the Supreme Court, plus the plaintiff, they may produce observations, present observations on the case. And then the application, the constitutional complaint, is examined by the plenary court, that is by the 9 judges of the Constitutional Court. There is an exception to that, but we can deal with this later if questions are addressed in this respect. Now, what decisions can be taken by the plenary court? This is very important when compared also to the Turkish legal system that we heard of much this morning and also in the afternoon. First of all, of course, if the constitutional complaint is unfounded, then the Constitutional Court dismisses the complaint. But of course, it is well-founded. If it is well-founded, the Constitutional Court can grant it in whole or in part, and then there is a question what it can do next. What is important, it can quash an individual act, judgment or decision, and remand the case for new deliberations. This is the most common way of addressing a situation where a violation is found by the Constitutional Court. There have been few cases, but very, very few cases, where the Constitutional Court itself decided on the matter, on the underlying claim from the original proceedings. It happened, for example, as a pilot situation, as a first case, when it happened, was a case of a TV show host who initially made some very strong remarks on a president of a political party. He was, namely the host, was then summoned by the editor-in-chief of that program and was asked not to repeat such demeanor in future. For that reason, that TV show host made several very strong, possibly insulting remarks regarding that editor publicly and made the public known what happened with very strong remarks. The editor started civil proceedings as a plaintiff, proceedings in damages in court, and was successful. The TV host show turned, in the end, to the Constitutional Court and was successful. The Constitutional Court said that the domestic courts of first instance, second instance, and so forth failed to examine the circumstances of the whole situation, didn't take into account that it was a case, initially a case of censorship. Now, the case was remanded for new deliberations, but also in new deliberations, the courts granted the claim of the plaintiff, of the editor. The TV show host came again to the Constitutional Court, and the Constitutional Court said, now that's enough. We decide about the case on the merits, and we dismiss the claim of the plaintiff, of the editor, in order to reinforce the position of the Constitutional Court. The Constitutional Court cannot grant just satisfaction, which to a certain extent is understandable because it only very rarely, only very exceptionally limits its findings just on the finding of a violation. But even in that case, the applicant can then start on that basis proceedings in a regular court and request damages for the violation found. In addition to constitutional complaint, there is another option for an individual application before the Constitutional Court, namely the petition to review constitutionality of a law in general or of its particular provision. Equally, an individual may start a petition, may lodge a petition for the assessment of constitutionality or legality of a bylaw. This is not an actio popularis, so-called. It is only available when the act in question interferes directly with the petitioner's rights, legally protected interests, or legal position. In practice, due again to the flooding of such petitions in the Constitutional Court, the Constitutional Court adopted a view, a standpoint, that access should be limited by, in the way that individual always needs to start proceedings in the regular court of first instance, assert unconstitutionality there, and only then later come to the Constitutional Court. Now, just shortly regarding the decisions that can be taken by the Constitutional Court in such petition proceedings. The decision is always made by the plenary court. It can, of course, dismiss such a petition, but if it's found well-founded, then the Constitutional Court may find that the impugned law, that the law in question or its provision is not is unconstitutional, is not in conformity with the Constitution, and order the Parliament to rectify the situation by a given deadline. It can also, for such a situation, decide that in the meantime, the law must be applied in such and such manner. But it can also abrogate the law with an immediate effect or with a deferred effect. The technique of decision-making of the Constitutional Court depends on the exact situation. I will not get into that more in detail, but these are the options available. To sum up, the constitutional complaint and the petition for review of constitutionality have been a success in the Slovenian legal system in the sense that they have led to several landmark decisions, well-established jurisprudence, erga omne effect, and clear independence from other institutions, other branches of power. But it has also been, to a certain extent, a victim of its own success by being submerged to a large number of cases and difficulties to deal with public expectations. I will stop here. I hope I haven't been too long, but I am really looking forward to your questions and to engage in a true dialogue. Thank you so much. Thank you.